Hey everyone, good afternoon. I'm Susan Coffin. I'm here for Attitude Magazine's weekly ADHD Experts broadcast. Today's session is part of our ongoing Fall Success at School series. You can find previous webinars in this series on our website and listen to them after the fact, even if you missed the live session. Today, we're going to talk about services at school. Pretty much all of us, all parents of children with ADHD or any other disability, are trying to figure out what academic plans or programs or accommodation or services will help their child at school. It's a complex question to answer, and all of us, I think, are often confused about the law and thus the services to request. So we're extremely fortunate today to have speaker attorney Matt Cohen, who will highlight the key advantages and disadvantages of the two major forms of accommodations, the IEP and the 504 plan. He'll be helping parents identify which solutions best suited for their child and strategies to maximize school services and also minimize the chance that educators will fail to enforce these invaluable plans. So Matt, thank you so much for being here. We really appreciate your time.
Happy to do it.
Let me introduce Matt to you. He is an attorney. He is the founder of Matt Cohen & Associates, and he specializes in special education and mental health law. He's a founder and a continuing board member of the Council of Parent Attorneys and Advocates, and a past president of CHAD, the National Attention Deficit Disorder Organization, and the author of a great book for any of you who want more information called A Guide to Special Education Advocacy, What Parents, Advocates, and Clinicians Need to Know. Let me thank the sponsor of this broadcast. We are grateful to our sponsors, without whom we could not do these webinars on a weekly basis. Today's webinar is sponsored by Play Attention. Play Attention is an advanced neurocognitive program. It's available for both children and adults. It is designed to improve attention, executive function, and self-regulation. Play Attention participants are assigned a personal executive function coach to listen and customize a plan for a child. Play Attention plan can be aligned with IEP or 504 goals. They're professional and they're at-home versions available. So if you're interested in learning more, call 800-788-6786 or visit playattention.com and request a free professional consultation. So thank you to Play Attention. And just before Matt starts his presentation, we'd like to ask you to tell us and share with everyone a little bit about the challenges that your child faces at school and what accommodations do you need? What do you need accommodations for? So you'll see a poll there on social skills, behavior management, academic support, or all of the above. If there's something else that you're interested in, go ahead and post that in the Q&A box, so we'll see that and know that that's your interest as you listen to the webinar. While you're taking the poll, let me just mention a few key points. It's really important to close out any open windows in your browser. This is a bandwidth intensive webinar, and if it slows down, it may be because there's not enough bandwidth on your computer. There is no dial-in number. It's internet exclusively. So all the widgets on your desktop are resizable. Move it around to make the desktop space work for you. You can download Matt's slides right now if you'd like to in the resource section and print those out. Some people like to take notes while the people are speaking. And later today or tomorrow, this webinar will be available for replay. Sometimes people want to share it with a spouse or the school on our website, attitudemag.com. So with that, let's see what the poll results are. Okay. Oh, all of the above for 48.8%. Well, Matt, no, this probably won't surprise you, but academic support also very significant. Okay, well, with that, let me turn it over to Matt. And again, with our thanks for being here today.
Thanks much. I'm happy to be here. I'm going to try to cover a lot of material in a very short period of time. So please feel free to go back and look through the slides if you need to. I'm going to be referencing a recent guidance document that was issued by the U.S. Department of Education, and I do have the URL for that guidance document, though I'm only going to be talking about it briefly. And as I hope you can see on this page, it does have my website and contact information, including my email address, so if people have questions, they can follow up with me after the session is over. I'll try to save as much time for questions as I can. What I'm going to be doing today is talking about IDEA in Section 504 with a focus to some degree on children with ADHD, but most of what I'm going to be saying is relevant to issues under both laws, regardless of what the nature of the child's disability is. It's important to understand at the outset that the IDEA is the special education law. It's a funding statute, which means the federal government gives states money in order to implement the law. And in return for the states getting money from the federal government, they essentially have to play by the rules of the law. It's, in effect, a bargain that they'll get a subsidy towards the cost of special education in return for honoring the legal requirements of the IDEA in the state's educational activities. By contrast, Section 504 is a civil rights law. It doesn't carry with it any funding whatsoever, but it only applies to entities that receive federal financial assistance. So because all 50 states receive federal funding and all school districts receive federal funding, every school district is bound by the requirements of Section 504 and has to agree that they will provide non-discriminatory services in relation to people with disabilities, including reasonable accommodations. So what we're going to be talking about today essentially are ways to leverage school services using each of the different laws in order to make sure that the child gets what they need, and particularly this is important in a time when in many states the availability of funds is less than it used to be. As I mentioned, under the federal law, the states receive federal funding. Those funds are shared with the individual school districts, and those school districts are bound to follow the requirements of IDEA. Under Section 504, because the school districts receive financial assistance that includes federal funding, they agree to not discriminate and to provide reasonable accommodations. The starting point for thinking about how each law might apply is to understand who is eligible for services or protection under each law. And the eligibility criteria under the two laws are similar in some ways, but very different in others. Under the IDEA, there are 13 categories of disability, each of which has its own criteria, and a student has to be determined to be eligible under at least one of those categories in order to qualify for special education. So the special ed law, the IDEA, is label-based. You have to have a label in order to get into the situation of being eligible for services. By contrast, Section 504 does not use categories for eligibility. Any student who is identified as having a physical or mental disability may be eligible for special education if they meet all three of the criteria under Section 504, which I'll talk about in just a minute. And to be clear, the issue of identification of a physical or mental disability requires that there be a diagnosis from an appropriately trained and credentialed professional that the person has a disability, but it doesn't necessarily have to be a disability that fits into one of the 13 categories of special education. So at the outset, if you think about just who might qualify, there are varieties of disabilities under Section 504 that are not within the 13 categories. By contrast, any child who has a disability under IDEA would automatically be eligible under Section 504 because they've already been identified as having a physical or mental disability. There are important rules specific to ADHD and Tourette syndrome in the regulations that were enacted in 1997 with respect to the IDEA. ADHD was explicitly added for the first time to the definition of other health impairment, or OHI, which is one of the 13 categories of disability under the IDEA. That specific category requires that a child have a condition that results in limited strength, vitality, or alertness, none of which seem to exactly fit ADHD, and that result in limited alertness to educational tasks due to heightened sensitivity to environmental stimuli. That qualifier was written by the Department of Education to expressly bring ADHD into the other health impaired categories. So it's very explicit from the Department of Education now that ADHD is covered, and as the slide indicates, in 2006, the Department of Education also amended the regulations to explicitly add Tourette syndrome as a covered health condition under the other health impaired category. Both ADHD and Tourette syndrome have been recognized by the Office for Civil Rights, which is the agency that is charged with both interpreting and enforcing Section 504 in the schools. The Office for Civil Rights has indicated for over 30 years that both of those conditions are conditions that are covered as potentially eligible under Section 504. So they are regarded as a mental impairment under Section 504. The other health impairment category under special ed includes conditions such as asthma, diabetes, sickle cell anemia, and as I mentioned, ADHD and Tourette syndrome. In order to meet the criteria to have an IEP under special education, though, it's not enough that you have the diagnosis. It's also necessary that the condition adversely affect educational performance. Just for the sake of those who have struggled to get eligibility in schools, many schools struggle with figuring out what constitutes behavior that is ADHD versus normal behavior, and many kids suffer a lack of services under either law, actually, because people are hesitant to give the label because they misunderstand both the symptoms and how to evaluate ADHD and Tourette syndrome. The other thing that complicates eligibility under IDEA is that many school districts now utilize a system called response to intervention, or in other places it may be called MTSS, or a multi-tiered system of support, which is basically a procedure in which schools refer kids who are in regular education to get extra help before they're determined to be eligible under either IDEA or Section 504. The federal government has said very clearly that if someone requests an evaluation for either special education or Section 504 eligibility, the fact that they have not received RTI services or are in the midst of receiving RTI services is not by itself a legal basis for refusing to go forward with an eligibility evaluation. But in many schools, unfortunately, the position that schools take is we can't evaluate until we've provided response to intervention services. And while that's not consistent with the interpretation of the U.S. Department of Education, many kids are delayed access to eligibility and services because the school is insisting on RTI first. All of the special education categories require that there be one of the 13 categories of eligibility met, require that there be an adverse effect on educational performance, and this is tricky, require that the child needs special education intervention. So it's a three-part test for whether the child qualifies for an IEP. The presence of the impairment, and the school has to agree that it's present, that it adversely affects educational performance, and that the child requires special education intervention. The schools often tell parents that special education intervention is in a special ed classroom. That's not correct. Special education intervention can include specialized help within a regular classroom, either by a regular ed teacher with the assistance of a special educator, or co-teaching or collaboration from a special ed teacher. So there doesn't have to be assignment to a special ed class in order to qualify for special ed. The other thing that schools and parents often get confused about is that the requirement under special ed that there be an adverse effect on educational performance does not require that it be an academic effect. The child can be qualified for special education based on social problems, behavioral problems, attentional problems, organizational problems, communication problems, even though the child does fine in terms of their grades or their achievement test scores. So it's very important to understand that an adverse effect on education performance includes all of the areas of functioning at school, not just academics. By contrast, under Section 504, if the student's impairment limits a major life activity, such as learning, working, caring for oneself, or thinking or concentrating, the student may be entitled to protection under 504. So not only is the definition of adverse effect broad under the special ed language, it's even broader under the Section 504 language. And in addition, while under special ed you need to receive some form of instruction, under Section 504, it's enough that the student receive or need special ed, related services such as the nurse giving the child the medication or a social worker helping the child with coping skills, or accommodations. So special ed, you need impairment, adverse effect on performance, and special ed. Under 504, you need a physical or mental impairment which substantially limits a major life activity and requires special ed, related services, or, and we underscore the or, accommodations. The short way to think about this is that it's very much easier to qualify for a 504 plan than it is to qualify for an IEP. So then what do you get once you qualify? Here's another place where a lot of educators and parents are confused because they assume that the child, and they're correct in believing that a child has a right to a free, appropriate public education under the special education law under IDEA, but they think that what they're entitled to under 504 is much more limited, and oftentimes people believe that all you're entitled to under Section 504 are accommodations such as a quiet room to take a test, preferential seating in the classroom, or extended time on homework and tests. And while all of those things are covered by Section 504 as accommodations, in fact, under Section 504, there is also a right to a free, appropriate public education, which includes, under individual circumstances, not only accommodations, but can also include related services like nursing or counseling, and it can also include, under some circumstances, academic support that's specialized to the needs of the student. What tends to happen in the real world is that because Section 504 does not include funding, so the schools have to provide for Section 504 services out of the regular education budget, as soon as the child starts needing services, schools frequently think about having them then be eligible for an IEP, because if they get an IEP, the state and the federal government are going to reimburse them for part of what they're qualified to receive, whereas under 504, they're not going to get any reimbursement. But in fact, there are many services under 504 that could be provided that schools frequently don't mention or think about, and that frequently are not provided because the school and the parents either are unaware that they're available, or the school actively doesn't want to provide them under that law because they'll have to fund it with regular education dollars. Another key principle under both IDEA and Section 504 is that under both laws, the child has a right to receive instruction in the least restrictive environment appropriate to meet their needs. And there are very specific rules under the IDEA requiring that the child be, to the maximum extent appropriate, be educated with children who do not have disabilities, and that the child be removed from regular education only if and to the extent that they cannot be educated satisfactorily in regular education with the provision of supplementary aids and services. So you're not supposed to move a child to a more restrictive setting until you've determined not only that they can't make it in regular ed at the moment without help, but that they can't make it in regular ed even with the help of things like supplementary aids and services, additional instructional help, accommodations, and even provision of things like a one-to-one aid. The federal regulations for IDEA also require that the child be educated in the class that they would be in if they didn't have a disability, unless the IEP requires otherwise, that they be mainstreamed as much as possible, and that they be educated as close to home as possible. The language in Section 504 actually tracks the language in IDEA very closely on the issue of least restrictive environments. So both have very strong rules regarding the need to serve kids within the least restrictive setting appropriate to meet their needs. Another place where there are important rules in both laws regarding children with disabilities, and particularly those with ADHD and Tourette syndrome, is with respect to discipline. And the IDEA has very, very detailed rules requiring that a child with a disability may only be suspended for up to 10 school days in sequence, or may not even be suspended for up to 10 school days cumulatively if the behavior is related to the same problem or there's a pattern of behavior, without convening something called a manifestation determination conference, or MDR, to determine if the behavior is related to the child's disability. And if the determination is that the behavior is related to the child's disability, they're not allowed to suspend for more than the 10 days. Even if it's determined that the behavior is not related to the child's disability, they still have to provide services that are sufficient to allow the child to make some progress on their goals and objectives. Again, although the details are not nearly as explicit under Section 504, Section 504 also requires that there be a determination of whether the behavior is related to the child's disability, and if it is related, they're not allowed to suspend for more than 10 school days. So very important protections under both laws. As I mentioned in the opening, in 2016, the federal government issued a very, very detailed policy letter, which included far more delineation of what the rights of children with ADHD were under Section 504. It included things like that the school district could not use RTI as a basis to not go forward with an evaluation of a student under Section 504. It indicated that children who are bright or gifted may still have the right to a Section 504 plan if their ADHD is interfering with their ability to function in school. It indicated that a child doesn't have to have failing grades or low achievement test scores in order to qualify if their behavior or functioning other than in the academic realm is problematic in some way, and that could even include children who don't have bad behavior but are socially isolated or have poor social skills and are not engaging with other students even though they're not misbehaving. So there were many different things that were in that letter that are very important, and people who are having difficulty should access that letter in order to give them a better idea of what some of the things are that they can ask for under Section 504. So I'm not going to go into all of the messages, but suggest that people reference that in order to have a good idea of what their rights are. Under IDEA and Section 504, as I mentioned, you're not only entitled to receive accommodations under both laws, you're entitled to receive special ed under both laws, and importantly for kids who are having behavior problems, there are a multitude of supports that may be appropriate under either law, including social worker or other counseling services, social skills training, one-to-one aids, a positive reinforcement system, parent counseling, medication administration, and even transportation if the disability makes walking unsafe. Now, I need to underscore to everyone that although I'm saying to you all of these things can be available under Section 504, most school districts don't know that they're available under Section 504, and even those that do know are probably going to be reluctant to offer these things under Section 504. So if your child needs these things, you may be in a position of advocating for an IEP, because these are all things that are explicitly set out as potential service options within the IDEA. So my point is that many things are possible under Section 504, but a short way to describe this is that the bigger the ask under 504, the more likely you are to get a no, at least under 504, and the more likely it may be that you should be asking as well under IDEA, because those things are more clearly stated as available under IDEA. Under the IDEA, the protections that were available prior to 2004 were weakened when the law was amended, and most importantly, and this is not something available under 504, under the IDEA, the school district may unilaterally place a student in an interim alternative educational setting for up to 45 school days if they have brought drugs or weapons to school, or if they have seriously injured another person or a staff member or themselves, or if they request a due process hearing to prove that the student, even though they haven't injured anyone, is dangerous to others or to themselves. So this notion of an interim alternative educational setting is basically a mechanism that allows schools to move a child to an alternative setting, which is supposed to be a special ed setting, but where they can work on their goals and objectives, but nonetheless, they're able to do that unilaterally for up to 45 school days, and there's no real mechanism for that under Section 504. As I mentioned, there is a requirement for a manifestation conference under both laws in relation to a suspension or expulsion, but under IDEA, the school district can decide that the behavior is related to disability and still unilaterally move the child to an alternative setting if they wish to do so. There are criteria under the IDEA that now require that the behavior be directly caused by the child's disability. It used to be that the behavior could be indirectly caused by the child's disability, so it's gotten harder to show the need for or the basis for the behavior being a manifestation of the disability. And under the IDEA, the school cannot put the child in an alternative setting if at the manifestation meeting the school determines that the IEP was not properly implemented in relation to behavior. And that's a reason why it's always important to make sure that you have a robust behavior plan in place, providing many layers of behavioral support so that the school has to think about other options before they think about transferring the child to an alternative school. The consequences I've indicated is that if the child is determined to have a disability that caused the behavior, they still have to stay in school, though they can move to the alternative setting. If there's a determination that the behavior did not cause the disability or there was no issue of failure to implement, then the child can be moved to an alternative school or even expelled, though they continue to have the right to some type of services under the IDEA. Under both IEPs and 504 plans, there is a right to have a behavior plan if that appears to be necessary, and I've already described some of the things that can be included in a behavior plan. One of the things at the bottom there that's very important, the schools are never going to create an exception to a discipline code for a child who's engaging in behavior that's dangerous to self or others. But there are symptoms of ADHD and Tourette syndrome that may be irritating or annoying or inappropriate that would be technically a violation of the discipline code where there should be an exemption. For instance, if a child has difficulty raising their hand and frequently calls out without being called on, that's an annoying and disruptive behavior, but it probably shouldn't be subject to school discipline. It should be subject to a behavioral plan that tries to replace that behavior and modify and reward appropriate conduct. And similarly, if a child had Tourette's and was making noises or using inappropriate language as a result of their Tourette syndrome, it wouldn't be appropriate to suspend them from school when they're unable to control the noise or the inappropriate language because it's a tic and it's a function of their Tourette syndrome. So those sorts of things should be discussed and potentially included as an exception to a discipline code under either an IEP or a behavioral plan. So under both, and I'm talking a little bit more about these things because it's such an important thing for kids who are having behavior problems, I think that parents and educators should think about building a behavioral umbrella for kids who are having behavioral problems. And here I've described a variety of different things that can be included, but it should include providing positive reinforcement systems and supports, including both things that the child may earn, but also, and this seems a bit odd, but just encouraging the teacher to provide more frequent and immediate feedback for good behavior. And that can be hard for a teacher to think about because you don't typically praise a student for not doing something, but in this case we want to provide reinforcement and praise for being quiet or cooperating or simply doing what's expected, and that can be helpful for a child with disability. The other thing that's often very important is to do functional behavioral analysis, an FBA, which is a process whereby there should be observation in the classroom to see what the things are that are actually causing the child to have difficulty in order to try to modify the things that are triggering the behavior, and even to look at what the consequences of the child's behavior are, because sometimes a child may act out in order to avoid or escape the behavior. So even if they are being punished, they may perceive the punishment as a positive because it allows them to avoid the things that they don't want to do. So all of these things are things that are important. The other thing I can't stress enough is the importance of providing for trusted allies as adults in the school. Have multiple people that the child can go to if there's a problem so that they can find someone who they feel comfortable with, who they trust, who seems to get what's going on, and so that you can avoid escalations and power struggles that can lead to more serious behavior and more serious discipline. Right. These are just additional comments and suggestions on the behavioral umbrella that I'm talking about, including monitoring what's being done to the child, for the child, and how the child is performing. And oftentimes it's possible through behavioral data to figure out that particular parts of the school day are problematic rather than the child has difficulty throughout the day. So then to wrap all of this up, there are many advantages to each law. It isn't possible to say that one law is always better than the other. It depends on the circumstances. So that IDEA has more stringent evaluation procedures and has much more stringent criteria for whether you qualify for services under the IDEA than under Section 504. The IDEA has explicit requirements that provide for the child to have access to the full continuum of services because the law sets out what that continuum is, starting with regular ed with support and moving all the way up to residential placement. So when I say the full continuum, I'm really talking about placements there. The law also has much more specific rules with respect to notice to parents, access to information by parents, and the right of parents to participate in all of the key decision making. They also have much more specific rules. If the parent and the school have a disagreement, under the IDEA, the parent has the right to request a due process hearing, and the rules are very detailed as to how that due process hearing system works, including, and very importantly, that the hearing officer can't be appointed by the school district. Under Section 504, there is an advantage that the eligibility criteria are less stringent, so it's easier to qualify. The regulations are less cumbersome, so it's less work to implement a 504 plan, and I think that most school staff find working under Section 504 to be less burdensome than it is to work under an IEP. The 504 plan, because it doesn't require a specific label, is less stigmatizing. There's less requirement for evaluation, and in fact, a school district could accept a note from a doctor identifying or diagnosing someone with impairments such as ADHD or Tourette syndrome without doing any evaluation on their own, whereas there are much more detailed evaluations under IDEA than there are under Section 504. And you can get a lot of services under 504 even if an IEP is not available. So you could get accommodations, you could get nursing service, you could get counseling or speech language services, and theoretically you could even get, for example, some resource support on executive functioning skills or time management or help with staying on task. So there are many things you can get under 504 even if you don't qualify for an IEP. If I had to say which is better by category, I would say that in general, a 504 plan is easier and maybe an acceptable option for kids who have less serious needs or for kids whose needs are primarily medical in nature and don't have educational needs as well. For example, if a child has diabetes and they need to have their insulin monitored, there isn't an educational need that they have, and so having a nurse involved is sufficient. If a child has significant academic needs, then probably an IEP is going to be more helpful to them because there's a more clear-cut set of procedures and goals, and there's greater accountability under an IEP than there is under a 504 plan. The place where I think it is most important that people advocate for an IEP versus a 504 plan is when a child has significant behavior, because the behavioral protections and safeguards under an IEP are substantially greater than they are under a 504 plan. So if you want ease and flexibility and you don't need as much, a 504 plan may be a good solution. If you need more services, or particularly if you have behavioral issues going on, or you need more sophisticated programming that isn't already available under 504, then an IEP is probably a better way to go. The other thing that may be worth mentioning, and this is in a sense true under both laws, but it's always easier to get something that the school has available than to ask them to get something and create something that they don't. And so there is a delivery system under Section 504, but it's much more limited than the delivery system that's available under special ed. And so as a general matter, if you need, for example, specialized reading instruction because of a reading problem or a sophisticated behavioral system or a lot of counseling or teacher support, those things are already mostly budgeted for under special ed, whereas they're probably not going to be available automatically or already in many school districts. So each family has to make those decisions carefully on their own. And here I've got some additional resources, including our website where you can find information on some of these things. And there are some additional resources for specific sites. And then this slide is a reference to my book on special education advocacy, which you can order through our office or on Amazon. So with that, I will wrap it up, open it up to questions.
Thank you, Matt. That was, I know it's a lot of information, everyone. So just to come back to the IEP versus 504, one of the questions that I think it might be a helpful one to pose at this point is what are some of the typical accommodations that a child with ADHD might be entitled to under a 504?
Sure. The most obvious and frequent ones would be preferential seating, quiet room for tests, extra time for tests and homework, and oftentimes monitoring from the teacher to make sure that the child understands the assignment and may even get help from the teacher on breaking up the assignment into discrete tasks. That's called chunking, so that they can figure out what to do more easily. You could get a nurse's assistance to administer medication. That's a related service. It's not an accommodation, but frequently kids with ADHD need meds at school, and the nurse could be written in as a provider under the 504 plan.
Okay. Specialized academic help, such as help with dyslexia or dyscalculia, or reading or writing help. There are some questions regarding that. Are those often falling under an IEP rather than a 504 then, based on your list, your citing of typical 504 accommodations?
Right. So the point that I was trying to make, and it's important to kind of differentiate theoretical from real world, is a child could qualify for educational services under a 504 plan, but schools are not used to providing educational services under a 504 plan, and they typically don't have a staff of teachers who are trained to provide those services under 504, and they do under special ed, or should. So once you're talking about that type of service, the school is more likely to think about whether the child needs an IEP or not. And for the parent, they're asking for those types of services, because as soon as you need instruction, then you're already addressing the third prong of the criteria for eligibility for special ed. So one of the things that typically, if a school is thinking about whether a kid qualifies for 504 or an IEP, is they'll say, well, we see the kid has trouble, but we don't see a need for special ed, therefore they don't get an IEP, they only get a 504 plan. So even though I'm saying that's not technically accurate, if that is present, then they're already qualifying for an IEP, so they ought to be arguing for that.
I see. Okay, so that's a really helpful, I think, clarification that if specialized educational intervention is needed, then it's time to try to get a child an IEP. Number of questions regarding schools that are refusing IEP, pushing toward 504, delaying IEP evaluation, not inclined to go the IEP route. What is your advice? I'm sure you see this often. What is your advice in those cases?
Say that again.
There are a number of questions regarding parents of children whose schools have been either avoiding IEP or pushing toward a 504 only, or in some way not agreeing to pursue the IEP, how should parents respond to that if, based on your description of educational assistance, an IEP seems more suitable for their child?
So the first thing that I would do would be to push for more robust services under a 504 plan, because if they're saying yes to a 504 plan, then you're already in that door, and you may as well try to get what you can under that option. In addition, it may be faster to get more services under under a 504 plan than to fight about getting an IEP. So, because just being practical, they're saying yes to a 504, then you're already there, and it's just a question of what do we do with the 504. In addition, once the parent starts pushing for more robust 504 services, it may cause the school to reflect, gee, if we're going to have to provide all of this stuff under 504 anyway, maybe we ought to just give them an IEP, and then not only have we satisfied the parent, but we're going to get some reimbursement from the state and federal government at the same time. And then if the parent really feels that the 504 plan is not enough and the school is not responding adequately, then the parent has the right to request a due process hearing against the school to challenge the refusal to do an IEP. And typically, before you get to a due process hearing, you would have an intermediate step, which I didn't mention yet, which is called either mediation or a resolution session, where you can work things out, and it's always good to work things out if you can. If the parent has requested a due process hearing at mediation or resolution, the school may realize we don't really want to have to go through a whole battle with the family about this, and so it may be possible to work it out at that level.
Okay.
Typically, if you're going to request a due process hearing, it's good to get an attorney or an advocate to help you because these can be very complicated and the stakes are very high in terms of what happens with them. And they may also be able to advise the parent on strategies to use either to enhance the 504 plan or to put more pressure on the school in relation to an IEP.
Okay, that's helpful. Yeah. Some questions about children who, how should I put this, are not doing terribly academically, but either their IQ suggests that they should be doing better, or they're doing well in school only at great personal cost, in terms of staying up all night or whatever. So how should parents address with the school a child whose grades may not look terrible, but who seriously has some other issues that would suggest that they need help?
It's a really important question, and there are a variety of ways to approach that. So I'm going to start out thinking about it in relation to a 504 plan, because that's somewhat easier. And that would be an example of a place where the federal government's guidance that was issued a year and a half ago would be very helpful, because the guidance has language that expressly addresses that. But that would be a great example of where the child may not be suffering academically, but is suffering in other ways. And what I tell parents to do in that situation is to keep a log of all of the things that are happening outside of school that the student is doing in order to keep up. How much time are they spending on homework? How many sleepless nights have they had? What is the parent doing? Are they providing extra tutoring? If there is an outside counselor or therapist involved, they should get a letter from the outside counselor addressing these issues. And under Section 504, those efforts actually have a name that's important legally. What those are called is mitigating measures.
Wow,
a mitigating measure is something that is provided that assists the student to perform, or the person with a disability to perform, in a way that allows them to meet the expectation for standard performance, but only because they're doing special effort that others don't have to do. Other examples of mitigating measures would be medication, eyeglasses, sound dampening devices, enlarged type on a computer. Those are all things that, in effect, neutralize some of the negative effects of the disability to allow the person to perform. But the school is not allowed to deny eligibility, or service based on the mitigating measure. So they have to think about how the child would perform without the mitigating measure, or take into account that they're having to make what is literally extraordinary effort in order to perform. And that's why all of that extra documentation is so important.
Right. Yeah. Sounds like the documentation is critical because schools.
Right. The other thing is that for many of those students, their academic difficulties may also be causing them a degree of anxiety or depression. And so, for example, I just won a 504 hearing against a high school where the student was very bright. She had very good grades. She was working extra hard after school on her homework, and she had a lot of anxiety about exams. And one of the things that we argued was that the absence of accommodation actually was causing some of her anxiety. So it wasn't just that the anxiety required extra time, but that the failure to accommodate caused the disability, and that student had ADHD. And so basically we argued that she needed the extra time because of the anxiety, even though she still got a good grade.
That's interesting, yeah.
And we were successful. The other thing that's important, just as a quick note, is that there is also interpretation from the U.S. Department of Education that says that a child who's gifted may still be entitled to accommodations under 504 and may even be entitled to special ed support with an IEP if their disability is substantially limiting, I shouldn't use that, that's 504 language, is adversely affecting their performance under the IEP.
Interesting, because there's a comment here from a listener who says her daughter has grades of 95 and above in all her classes, but she's dyslexic and she spends all night literally reading. So it sounds like that's exactly the case that you're describing, where she would be eligible, certainly for 504, if not IEP, possibly, right?
Typically, school districts typically have rubrics for how much time students are supposed to study for each class and for each grade level. And it's useful for the parents to ask the school for those guidelines, because if they can show that their student is having to spend time that's well in excess of what the district's guidelines are, that helps to make the argument that this is excessive and that they are entitled to some accommodation.
Right. Okay. That's helpful. There are a number of questions relating to private schools and colleges. I'll sort of summarize those. Do private schools have to follow these laws? My child attends a private school. Is he entitled to the same accommodations? And then a third category, my child has an IEP at 504, but is going to college. Will he be able to carry that with him to college?
Okay, so those are all really important questions. So I'm going to have to take that in several steps.
So, okay.
The first thing is that the IEP, special ed services, don't apply to private schools at the elementary and secondary level unless they're contracting with the public school district. And they don't carry over to college at all. So the IEP terminates when a child graduates or ages out of public education, elementary and secondary education, period. A 504 plan, or at least the eligibility for a 504 plan, applies to any institution that receives federal financial assistance. So if a student is in a university or college that receives federal funding, they may qualify for a 504 plan there also. And the fact that they had a 504 plan in high school will help them to get a 504 plan in college, but that's not an absolute prerequisite. So I do have clients, for example, who made it through high school without a 504 plan and they're not diagnosed until they get to college. And it's harder to get accommodations under those circumstances, but it's not impossible. You have to be able to show why the student didn't need the help when they were in high school. And sometimes all of those mitigating measures that I talked about are enough to allow the student to get by in high school, but not enough for them to get by in college. And so
right.
And then there's a third law, which is the Americans with Disabilities Act, and that will also apply to private elementary and secondary schools unless the elementary or secondary school is religiously controlled. So there is a right to reasonable accommodations in private schools elementary and high school, unless they're parochial schools or religious schools. And the Americans with Disabilities Act also applies to colleges and universities, again, unless they're religiously controlled. But the evaluation process in the private institution is influenced by what the public school has done for the student, but it doesn't automatically carry over.
Okay. Yeah, we had actually a great speaker on college disability services, and I would refer listeners to our website. She described typical college disability services, which are considerably less than IEP or 504 for the most part.
Well, that's important. It's not just that they're considerably less. There is no obligation at the college or university level to find that the student has a disability.
Exactly.
Elementary and secondary school, the burden is on the school to figure out who has a disability. In college or university, the student has the obligation to come forward and say, I have a disability, I need help.
Right.
And there's no obligation to provide specialized instruction. It's just accommodation and support.
That's right. That's right. Yeah. So some questions about the specifics of accommodations, especially parents of children who have behavior issues. So anger, one person says, our son gets very angry. Other behavior problems, social problems. What is the best course of action for parents who feel that their children's emotional state in school is a problem?
Well, so I think that I would respond generally by saying whether the problem is anger or depression or anxiety or bullying, those are all behaviors that stem from a cause and an emotional state, and they all have to get figured out regardless. Right. I wouldn't have my answer be limited to anger. I would just say that when the behavior is externalized, in other words, it's directed to other people, it's more likely to be disruptive, and it's more likely to both be noticed and to result in discipline as opposed to either being ignored or just resulting in limited response. So it becomes a bigger problem because the system is affected by it more, and the risks and consequences for the student are greater. But in either case, it's important to both figure out where is it coming from, what's causing it, because it's very hard to deal with an emotion or a behavior unless you know what its origin is. And then that's called an antecedent, and then look at what is the result of this emotion or behavior, what are the consequences, and then figure out, are there things that are because the student is angry about something? What are they angry about? Is it because they can't read, or they're getting teased, or they're not getting enough attention, or they're embarrassed about something? And then the next question is, do they have the skills to understand and manage the behavior? And if not, we need to teach them the skills to understand and manage the behavior. And at the same time, we also have to look at what's happening around them that perhaps we need to protect them because they're getting bullied, or because they're getting overstimulated, or every time the buzzer goes off at school, they get dysregulated. And so we have to figure out a way to help them to deal with the buzzer going off. So rather than looking at the behavior in isolation as something that's the child's fault, we have to understand why is it happening and what are the skill deficits, environmental modifications, and supports that the child needs in order to help with it.
And is that the school's responsibility to determine what the causes of the behaviors are, or are you advising that parents?
Well, that's a really important thing. I guess it is a school responsibility, but if I were a parent, I wouldn't want to rely exclusively on the school to figure that out.
Okay. You want to be able to have some documentation and take that to the school.
Right, and it's also, while sometimes the behavior is just school-related, it's oftentimes got a home component, and in addition to that, because you can't always control for what the school is going to do, or even you might have a great plan on paper from the school, but the people implementing it are not very skilled or experienced. I'd want to make sure that I have some private support also to ensure that the appropriate interventions are being done and with the appropriate quality.
Okay. So in terms of serious behavior problems, you probably want to bring in some outside assistance. Matt, you talked about what a serious decision it is to bring a lawsuit, to hire a lawyer in order to press for an IEP. Is that similarly the case if the school declines a 504? What are parents who believe their child would benefit from a 504 to do if that's declined by the school?
Yeah, so the one thing that I didn't mention in relation to a 504 plan is that you can request a due process hearing, or you can file a complaint with the Office for Civil Rights of the U.S. Department of Education. And you don't need a lawyer to do any of those things under either 504 or under special ed. But the painful reality is that you're a lot more likely to be successful with a lawyer under either law than you would be doing it on your own.
Okay.
On the other hand, either step under either law, even the decision to involve a lawyer, is a significant escalation. And with or without a lawyer, I would say it's important to try to work things out with the school district as much as possible in a friendly or collaborative way before you get to the point of filing a complaint or requesting a hearing.
Okay.
Because at the end of the day, the parent and the school, whatever their feelings are, the kid's going to go back to school.
Right.
And everybody still has to be able to work together, and the kid has to be able to manage, and the people still have to be able to talk together and problem solve. So, for example, I'm being texted as we're talking today by a school lawyer in relation to a child who's apparently at school biting staff. And the parent and the school are not talking to each other, so instead of working out a solution to the kid biting the staff, they're fighting. And that means that everybody's being hurt while the fight is going on.
Right.
So it's always better to figure out a way to come up with a solution everyone can agree on than fight about it.
Right. Then so do your best to work it through before you resort to the legal option. Interesting question here. Her parent whose child has been referred to for dyslexia testing by a doctor, but the school says that's outside their expertise. They don't have the expertise to test for that. Is that a common response to a serious reading or other learning disability, and how should a parent respond in that case?
Well, first, there's a huge amount of confusion in both the parent, clinical, and school community about whether dyslexia is different than a learning disability. And dyslexia is just a way to clinically describe one type of learning disability.
Right, and it's a learning disability, yeah.
The schools have an absolute obligation to evaluate children suspected of having learning disabilities, whatever the subtype is. So if they don't have the people who are qualified to do that evaluation themselves, and this is a big shocker for schools, but then they're obligated to pay for someone who is qualified to do it. So the one way or the other, from my perspective, the issue isn't whether they will do it, it's just who does it, and does the school do it themselves or pay for someone privately.
Okay. So that might be difficult, though, for parents to persuade the school to pay for a private learning disability evaluation.
Right. So that would be an example where then the parent's next step would be to request a due process hearing, and then the school district would be facing having to spend more money to fight about the private evaluation than they would spend to have the private evaluation.
I see. Okay. So, yeah, requesting the due process hearing would be the next step. Interesting. Is it typical for a school district to write the language of accommodations loosely, and should parents be more specific? So, for example, my child is having to share a standing desk. Should the accommodation be specific and say, for example, standing desk for use only by the student? I guess a more general way of asking that question is, how specific should the accommodations be? I'm guessing is as specific as possible, probably, right?
Well, I would say it's actually one of those things where I'm reluctant to make an absolute global statement because in general, the more specific, the better. but there might be times when you want there to be flexibility, and being too specific, we'll only be allowed to go to the bathroom for 3 minutes from 122 to 125.
Okay.
It could limit the child's ability to get what they need. The other thing that parents should be aware of in terms of the specificity issue is that frequently the accommodation will be qualified in one of two ways. One is going to be that the child will be allowed extra time when they ask for it, or even that they'll be allowed to go to the nurse to get help with the med when they ask for it. But the child isn't going to ask for it, or doesn't have a good sense of time, or may be embarrassed, or they have ADHD and they're disorganized, and they're not going to ask for it. So putting it on the child is a mistake, because it may make it likely that it doesn't happen rather than it does.
Right.
The other way that accommodations are sometimes qualified is that it's at teacher discretion or as needed, and then the teacher decides it doesn't need it or doesn't notice, or they have a different threshold for when it should be done, and so it doesn't happen. So in most instances, my view would be that you start out with the accommodation and then you wean off it if it turns out not to be necessary, rather than saying as needed and then it's not given. The other thing that's a very important point to make about that, and I know we're coming towards the end, but accommodations do not teach skills. Accommodations allow a person to work around a problem with adult support or outside support. So it's very important to teach the student the skill they need themselves, as well as provide the accommodation, and they shouldn't be mutually exclusive. So for example, if a student has trouble understanding directions, there should be an accommodation that the teacher will repeat the direction, but the student also needs to understand to ask for help if they don't understand the direction, and that should be a goal, that they will ask for help.
Yeah, self-advocacy. We've had some great webinars on that topic, and it seems to be really a critical part of parenting kids with ADHD and learning disabilities. I'm so sorry, we're going to have to go. We're out of time. Matt, you've been so helpful. It's so clear. And I know everyone's very grateful. So thank you for your time. Listeners, we have some three wonderful webinars coming up in October. This is ADHD Awareness Month. Next week, we have Stephen Hinshaw on girls and women with ADHD. He's an amazing speaker and a great expert on that topic. On Tuesday, October 23rd, Mark Burton will be talking about ADHD and autism. When it's one, when it's the other, when it's both. And then for Halloween, on October 31st, we have Ned Hollowell and William Dodson on Pride and Truth, celebrating ADHD differences, getting over shame and stigma. So that should be our big ADHD Awareness Month webinar, and I hope you'll all join us. Thanks so much to everyone for listening in, and thank you, Matt Cohen.
Thanks.
As always.